Hello, everyone.
Hello.
I want to ask from all of you, am I audible to all of you?
Yeah.
Okay, thank you. So, good afternoon, ladies and gentlemen. Welcome to the Forensic.India's International Law Conference on the role of expert witness in court proceedings. I am Usha Shishodia, organizing member of Forensic.India. In today's conference, we will came to know about the different aspects of expert witness, like who will be called as expert, what kind of testimony he or she admitted to the court, what are the cases in which there is a need of expert testimony, what are the proceedings through which the expert testimony will be presented in the court, and many more. And before hearing our expert views on today's topic, the Forensic.India would like to thank Nelson Mandela University, South Africa, for believing in our work and collaborating with us. The Forensic.India is highly grateful to the university. Now, the conference is carried forward by the introduction of our today's keynote speaker, who are pioneers of their field. Our first keynote speaker is Advocate Ms. Tara Trigoni. She is an attorney of the High Court of South Africa, has an experience in the field of litigation, criminal law, civil law, family law. In her career history, she joined various organizations like Annalee Erasmus, Brown, Brown Broder, and Walsh Attorney, Legal Aid South Africa, and many more, and explored her career in every aspect. Our second keynote speaker is Ms. Advocate Kanika Bhardwaj. She is a lawyer of both criminal and corporate sector, handling cases from all over Delhi, NCR, Mumbai, of High Court and Supreme Court of India. Apart from that, she had also acquired a position in a panel of Yamuna Expressway Industrial Development Authority. Now I would like to request our first keynote speaker, Ms. Sarah Ma'am, to start the conference by sharing your views, your ideas on the related topic.
Thank you. Good morning. Well, good morning for me. Good afternoon to all of you. And welcome. Thank you for having me, Forensic.India. Just to introduce myself, can everyone hear me clearly?
Yeah, yes, ma'am, you are audible.
Perfect. Okay. My name is Tara Trigoni. I'm an attorney of the High Court here in South Africa, practicing in Port Elizabeth. I have my law degree from the Nelson Mandela University, which I received a few years ago. I then went on to study my master's degree in medical law and ethics at the University of Pretoria, which I graduated cum laude. And yes, since then, I've gone on to work in both criminal and civil law. I spent a few years at Legal Aid South Africa, which is our state-funded criminal defense attorney organization. So we represent the criminally accused in trials. I was there for a few years, and then I moved on, and I'm now currently working in the civil sector, the private sector, as a family law attorney in Port Elizabeth. So I've been asked to share some insight into the role of expert witnesses, and we'll get going now. Now, obviously, you'd understand that there's a need for expert witnesses. A presiding officer in legal proceedings naturally can't know everything. And while their knowledge may be vast, they are, at the end of the day, still only a legal practitioner, often without any other experience in any other fields. So as a result of that, there are issues that may arise during the course of the legal proceedings, which simply cannot be decided without the assistance and guidance of an expert. Also, before I carry on, I want to just say I was unfortunately not really able to participate yesterday due to my schedule. So if there is a bit of overlap, please do forgive me. But yeah, the issues that the court might need guidance on usually, would relate to, for instance, ballistics, engineering, chemistry, medicine, psychiatry, accounting. All of these the court would often require guidance. And this list naturally is not exhaustive. There could be a multitude of topics that the court doesn't have insight into and will require guidance on. For instance, here, our case law shows that courts have allowed a typist to come testify as an expert. Not the expert in the usual sense, but she was an expert with experience in her chosen field. And also motor vehicle mechanics, often used, especially when there's been a collision, and that's the basis of the litigation. So even if the opinion evidence isn't absolutely necessary, if it will be useful to the court, it may be admissible. The general rule of thumb is that the opinion will be received because and whenever the expert's skill is greater than the court's, which, unless it's on a legal topic, is most of the time. It's also not always necessary for the expert to testify orally in court. There are instances where the court will accept the expert's evidence in the form of either an affidavit or a certificate. And this is particularly so if that expert's opinion isn't being disputed by the opposing party. However, if that evidence is disputed, the witness will most likely need to be called to court to allow the other party to cross-examine and test that evidence. Then there are certain instances, then the affidavit itself has to contain specific information. Now, in South Africa, our criminal proceedings are governed by the Criminal Procedure Act, and this act also stipulates what needs to be contained in an expert's affidavit. So, according to the act, if there has been a fact that's been established by examination requiring skill in the sciences or maths or statistics, computer science, ballistics, fingerprints, to name just a few. The field is actually endless. The expert who established that fact will need to depose to an affidavit. So that affidavit will need to state that they are either in the service of the state, the provincial administration, a university, or another recognized body. And when I say recognized body, I mean it's recognized in terms of government regulations. So it can't just be any organization or any body. It has to be recognized in terms of our regulations. And then in their affidavit, they will need to confirm that they themselves has established the fact in question by means of examination or whatever process was used. So the reason why I emphasize they themselves is because for instance, if I'm deposing to an affidavit as an expert, I can't state that my colleague found X, Y, and Z, or came to X, Y, and Z conclusion, because that then just merely amounts to hearsay. And as I'm sure we all know, the general rule is that hearsay evidence is inadmissible, can't be received by the court, with the exception being expert evidence. You must also confirm in your affidavit that you have established the fact by way of an examination or process. Now, it isn't required in terms of the legislation that that technique that you used, the process that you went through in order to reach your opinion, has to be described. But in practice, it is always done, because without that, little to no weight can really be attached to that evidence. So this, by describing the process that you follow, it gives the court insight into your thought process from the moment you received the evidence in whatever form, whether it was, inspection, samples, interviews, in the case of psychiatric evidence specifically. And without explaining that process, it will be difficult to show that there is in fact a link between the evidence you received and the opinion you came to. So this leaves open, room for the opposing party to attack the reliability of your opinion, and your findings. It opens up space for doubt to be sown in the case. Yeah, so it's always, best to, even if it's not specifically required for legislation, like in terms of legislation, it is always best to at least describe the process that you've undertook. Now, when you're deposing to an affidavit, and making specific reference to, fingerprints or body prints, bodily samples, so, blood, mucal samples, semen, that anything, or samples from the crime scene, dirt, paint scrapings, cigarette butts, I know they get used quite often as well. You'll have to state in your affidavit where that's, or how that specific evidence was collected, where it was collected, whether it was at the crime scene, whether it was retrieved from a specific person, where that took place, and whom obviously the person was. If that evidence only came up under, when being analyzed in a lab, you need to state that. And also, the affidavit needs to state who it was that dealt with that evidence. As I said before, if it wasn't you dealing with that evidence, then it's just hearsay and it can't be used. So it has to be the person who actually physically examined and analyzed the evidence that will need to depose that affidavit. Then, aside from that affidavit, there'll also be affidavits that are drawn by every person who handles the evidence. So from its collection, the person who collected it themselves, even if it's merely for safekeeping, anyone who had that evidence in their possession will need to depose an affidavit. They'll have to, first depose that affidavit, but also that affidavit must also set out when they received the evidence, where it was kept, and under what conditions and circumstances, and when it was handed over to the next person. To give you an example of this as well is when it comes to cases involving driving under the influence of alcohol. So I'm not sure about in India, but in South Africa, we have a massive problem with that. Half the district court rolls are clogged up with cases of drunk driving. So in that case, the blood sample that's drawn from the accused person, every person that handles that has to do an affidavit stating when it was received, from which other police. It's handled generally by the police. So from which other officer they received it, the time, not even just the date. It has to state the date and the time it was received, and where it was stored. And obviously, I'm sure you all know that is essential in a drunk driving case, because if it wasn't stored properly, then that opens up, a whole can of worms in terms of it can be challenged on the basis that if it wasn't the right temperature, that it needs to be stored in a fridge. If it wasn't the right temperature, then that blood sample is useless. Also depends on how much time elapsed between taking that blood sample and having it tested. and also from the moment of arrest to the taking of the blood sample. So here, if you are arrested for drunk driving, the police have 2 hours in which to take you to a hospital to have your blood drawn. As soon as they don't, then, if they overstep that 2 hours, then that evidence is useless, and there goes the state's case pretty much in an instant. It's that easy. So what these affidavits all show is obviously the chain of custody. Any break in that chain of custody could easily be enough for a return of a verdict of not guilty in criminal proceedings. So in order to avoid that, you need to make sure that every person, as I've stated earlier, deposes to an affidavit. Here in South Africa, the state in criminal proceedings have to prove their case beyond a reasonable doubt. That concept is also sometimes difficult to define. But as soon as there's been a break in the chain of custody, then it's easy to raise doubt as to whether the evidence was properly handled, and opens up the possibility for the evidence having been tampered with, which is also something that, believe it or not, or unfortunately, is something that needs to be considered, because it happens more often than it should. Then, of course, it's not only forensic experts who are called to be expert witnesses in court and provide their opinions. It ranges from mechanics, as I've said, vehicle mechanics, to typists, to doctors, psychiatrists, social workers. That's, I'm currently working in family law, so we deal a lot with children. So you're constantly having social worker reports and psychiatric reports. And obviously, if a matter goes to trial, we have to call those witnesses. But for any party, before any party may call a witness, the general rule, obviously, as I've said, is that opinion evidence won't be received by a court. So specifically, any opinion, whether or not it's from an expert or a non-expert, which is expressed on an issue that the court must decide for itself, and which the court can decide for itself without receiving that opinion, that evidence and that opinion is then inadmissible, simply because it's irrelevant. The duty always lies with the court to make the ultimate decision. The court is the fact finder, and the expert's role is merely to guide the court. So this so-called opinion rule protects that fact-finding function of the court. It's also sometimes referred to as the ultimate issue doctrine, which is simply put that a witness may not express an opinion on an ultimate issue which the court has to decide. But before calling an expert witness in any legal proceedings, whether it's criminal or civil, the parties to that expert will need to lay a foundation and will need to satisfy the court that such evidence is in fact relevant and will be helpful to the court. And relevance in this, in these circumstances, isn't just a matter of being logically relevant. It has to be legally relevant. And for something to be legally relevant, that's a topic that we could speak on probably for a month, because it is complex and intricate, and there are so many little nuances to it that also unfortunately fall outside the scope of what we're discussing today. But in South African law specifically, to satisfy the court that evidence is relevant and will be helpful, the court needs to be satisfied as to three things before they'll allow the testimony. The first thing is that not only does the expert have specialist knowledge, training, skill, and experience, but on account of this knowledge, skill, training, and experience, he or she can assist the court in deciding the issues. Now, also what has been interesting in the case law as well is that it's not always formal qualifications that are required. So if someone has enough experience in a particular field, and that experience alone can help guide the court to a reasonable conclusion, then that evidence can be accepted. It doesn't have to be, they don't have to have a university degree or a certificate, or obviously sometimes that will go, and this depends on the nature of the evidence and on the nature of the issues. But yeah, it's not always formal education that's required. So that's the first thing that needs to be satisfied. The second point that the court needs to be satisfied on is that the witness is indeed a specialist or an expert for the purpose for which they're called to express an opinion. So, I mean, this requirement, I think, is also quite self-explanatory. You can't have a mechanic come give evidence on an engineering issue. It just doesn't make sense. So again, it would just be superfluous and irrelevant, and the court will never accept that. There was a matter, a case that I read through, Schneider, N.O. versus Aspling, where in terms of qualifications as well and titles, the witness there, the expert witness, was, she referred to herself as a professor because she had once been working at a university. She no longer worked at the university. And the court actually lambasted this witness for referring to herself as a professor when she wasn't entitled to do so. So it's very important also not to claim qualifications and titles that you don't have as an expert. It negatively affects your credibility, and it definitely won't help the case. Then the third aspect that the court must be satisfied on is that the witness does not express an opinion on hypothetical facts. So in other words, facts that have no bearing on the case, and which cannot be reconciled with all the other evidence in the case. Again, it's quite a self-explanatory requirement. It would be a waste of the court's time, essentially, to have someone come to court and give evidence that doesn't pertain to the facts at hand, and will be of actually no assistance to the court in trying to solve the issue at hand. So when, as an expert, you're giving giving evidence, whether it be oral or written evidence, you are in principle required to support your opinions and findings with valid reasons. Simply expressing an opinion will not assist the court, and bold statements of opinion are not readily accepted by courts either. But this isn't a hard and fast rule. It depends, as I said previously, it depends on the nature of the issue at hand, and also furthermore whether there is in fact an attack on the expert's opinion. To be safe, it's always best to lay out your reasoning and the process you followed in order to come to your conclusion. If this process is logically laid down, and your conclusion and opinion being the only reasonable conclusion and opinion that could have been reached in the circumstances, it obviously leaves very little room for the opposing party to object to that evidence or to attack that evidence. Additionally to that, the court needs to be able to follow your reasoning. There are obviously exceptions, but the court must be able to follow and to see how you objectively came to your conclusion. That way the court will know and be able to weigh your evidence and attach a certain weight and value to it. Despite the fact that you may be the expert on the subject matter, it is still the court's decision on whether or not to accept a certain fact or to accept your opinion. So a failure to furnish the court with the reasons for your opinion will affect the weight. It's not necessarily the admissibility. There are times where the court, and frequently in fact, where the courts receive opinions of experts where it isn't necessarily supported by reasons. But as I said, just a simple, bold statement that this, of the fact, this is the way it is, this is my finding, that won't go very far, and that will rarely be accepted. Another reason why it is advisable to always lay out your reason is that a failure to do so, as I've said earlier, can take away from the value or leave it without any value. And if it's found to have no value, no probative value, then of course, then again, your opinion or your evidence is irrelevant and inadmissible. So it won't be able to be used. And yeah, when giving your evidence, well, the court, when listening and receiving evidence from an expert, they have to look at that evidence as a whole, and against the other evidence in the case. So they'll have to be able to reconcile the expert's opinion with the rest of the evidence. And they can only obviously do so if the reasoning is laid out clearly. That evidence as a whole will obviously also need to support the eventual verdict which the court comes to. So I mentioned earlier that your evidence mustn't just be logically relevant, it also needs to be legally relevant. So as I stated, that's a topic that we could speak on for ages. But to sum it down and to distill it to its essence, what legal relevance entails is that the opinion of the expert is based on facts which are so related to other facts of the case that in the normal course of events, those facts, either taken alone or in connection with each other, either prove or render probable, so render likely, the past, present, or future existence of the said fact. So yeah, it is complicated, and I'm sure that if and when you're called to be an expert witness, the practitioner calling you, either the attorney calling you as a witness, or if it's the court has that power. They will be able to, it's not for you to decide whether it is legally relevant. They will need to have canvassed that beforehand. And if it isn't legally relevant, well, the court will let you know very quickly. There are obviously, as I said, instances where evidence is so technical that a court won't be able to follow. And especially, a legal practitioner, so the presiding officer with a legal background and no background, for instance, in, advanced sciences, they're not really going to be able to possibly, I speak under correction, but it's unlikely that they're really going to be able to fully grasp the concepts that you put forward as an expert, obviously without the same skill set that you have, which is why you're actually at court. And in these instances, the courts place great emphasis on the general repute of your profession. So all forensic, they look at what, the reputation of all forensic scientists, or all doctors, or, all statisticians. And it's in these situations where it's really, really important as an expert to remain objective and impartial. Your job as an expert witness is not to sway the case either way. It's always essential that when giving evidence, you remain objective and transparent, because otherwise, it could be said that you are a hired gun, as we like to call it. So not in fact there for your expertise, but just there to try and swing the case. And this problem has actually been around for a lot longer than what we'd imagine. There was a case in an English case in I think it's 1873, Lord Arbinger versus Ashton, where the judge there, he noted that there's obviously a natural bias to do something that's serviceable for those who employ you and who pay you. And, I know here in South Africa, an expert witness is paid for their time in court. So obviously, as the court in Lord Arbinger said, it's natural to then want to, service your client or your employer for the day. And so much so that even back then, in over a century and a half ago, they were seeing people constantly, instead of considering themselves to be witnesses, they held themselves as paid agents of the person who called them. Now, yeah, that's again of little assistance to the court. It needs to be an impartial opinion based on the evidence. No, it can't be your general feeling towards something. It has to be based on evidence and given to the court on an objective basis. Good and bad facts. You can't just ignore the bad facts and the bad evidence, evidence that doesn't support your conclusion. Now, in criminal proceedings, you'll either be called as a witness by the state or by the defense. In civil proceedings, it's either by the plaintiff or the applicant or the defendant or the respondent, depending on obviously the nature of those proceedings. Now, despite the fact that you're called as a witness by one of these parties, your position needs to remain neutral. If there is bias, in your opinion, very little to no value can be placed on it, and it will be excluded. And there's also, you run the risk of, again, being lambasted by the judge when they are delivering their judgment. So it is essentially also your reputation on the line, and that's not worth risking for anyone's sake. Excuse me. Now, the procedural aspects before calling an expert witness, specifically in South African law, and our civil law specifically, requires that before you call an expert witness, you will have to give, as the legal practitioner, you'll have to give your opposing party and the court notice of your intention to do so. You also have to deliver to them a summary of your expert's opinion, as well as the reasoning. And in civil matters, this is done by the process of discovery. I do believe a similar process is followed in India. All this is that it's to allow the other party knowledge of and eventually access to the documents and sample recordings, in our instance, that the opposing party or that you intend to use in court and that might be relevant to the proceedings. So here our discovery process is very straightforward. What happens is you, at the close of your pleadings, so after pleadings have come to a close, you will deliver to your opponent a notice to discover, calling on them to provide you with a discovery affidavit. They will obviously serve the same on you. And then within 20 days after receiving that notice, you'll do a discovery affidavit. So these affidavits have two schedules. The first lists all the documents which are, and when I say documents, I also include tape recordings, and which is given an extended meaning in our law. So it's, tape recordings, it's also emails, correspondence, video, pretty much all electronic kind of media. And so the first schedule of this affidavit then lists all those tape recordings and documents that are in your possession at the time of deposing to the affidavit, or which have previously been in your possession. Then that schedule is divided into two parts. The first part will be list the documents and recordings that you do not object to the other party inspecting, because obviously they have a right to inspect it before trial. And then the second part is the documents and recordings that you do object to them inspecting. And those will be, usually your documents and recordings that fall within the ambit of privileged. So that's in civil law, where you follow a discovery process, so that you can say that the trial is fair, and in terms of our constitution, that is a right guaranteed to a party in legal proceedings, and specifically to an accused person. But now in criminal law, prior disclosure is not necessarily required. So this is in terms of the law. It can be demanded, and it should be granted on constitutional grounds, and specifically, as I mentioned, the accused person's right to a fair trial. So even though the legislation doesn't specifically require it, in practice, in criminal proceedings, the state have to disclose if they intend to call witnesses, who those witnesses are, and whether they intend to rely on expert evidence, either in the form of an affidavit or a certificate. That is obviously now aside from calling that expert as a witness. This gives the defense counsel an opportunity to peruse the evidence in order to establish whether to admit or deny or challenge that evidence. And obviously, it gives them an opportunity to determine whether or not they in fact do have a defense to the case. So for us, whenever you go to trial on a criminal matter, as the defense, you have a right to the police docket. So all the evidence of the state, you have a right to a copy of that, so that you can adequately prepare. That's only at trial though. So before trial, you obviously don't have insight into the docket. And our bail proceedings, for instance, when we proceed on a bail, there's no right to the contents of the docket. So in those circumstances, the state can, come with this surprise attack. Usually the courts will never allow for a trial by ambush, as we call it, but bail proceedings are different. So you don't have insight into the docket, and it is very much a chance for you to be caught by surprise. And that actually happened to me a few years ago. I had a client who I was busy with his bail application, and he had been accused of rape. And obviously I had consulted with him, and he informed me, no, it's completely untrue, denied all the charges against him, which was obviously a relief for me as the practitioner at the time, because then you think, okay, cool, we've got a case here, and reasonable grounds for bail. So we went into court, and I was still really fresh out of university as well. It was one of my first bail applications at the court that I was at, and as the applicant, we began. So I laid out our case. We proceeded by way of affidavit. So he didn't actually testify in his own bail application, because if he had been cross-examined and said something detrimental, that could be used against him later on in trial. So we thought, okay, let's just put on an affidavit. We proceeded, and felt quite good, you know. It didn't seem too bad. It seemed, you know, reasonably possibly true, which is the burden of the accused, that his version be reasonably possibly true. And then the state got up to give their evidence, and we didn't know that they were going to come with the medical evidence, and it was just an absolute disaster. It was, yeah, the doctor's report, and there again, it was by way of a report. The doctor wasn't called to testify. The court didn't see a need because they had deposed this affidavit. And yeah, we were completely like caught off guard, ambushed, so to say. And naturally, bail was denied. And I actually believe that client never made it to trial. I think he actually passed away while he was in custody. But anyway, moving on to when you are actually giving evidence in court orally. So the primary function of an expert witness is to guide the court to a correct finding on questions found within their specific specialized field. So I've used the word guide quite a few times, I think, already today, but you know, it's important to remember that the decision of the expert should not ever displace that of the court. The court has to determine the issue to be tried, and as I've stated, the expert should never usurp the function of the court. But at trial, when giving oral evidence, you know, cross-examination in both civil and criminal proceedings is obviously a fundamental right. It's an essential component in adversarial and accusatorial systems alike. And a litigant in both civil and criminal proceedings has a right to cross-examine any witness called by the other side who has been duly sworn, including an expert witness. And, you know, if they are, for whatever reason, denied that right, you know, and prohibited from cross-examining for whatever reason put forward by the court, that amounts to an irregularity and is enough to have those proceedings set aside completely. Or if there's, you know, after judgment, if a verdict is given, that's enough to have that whole verdict set aside. So the purpose of cross-examination in court is to elicit facts that are favorable to the cross-examiner's case, as well as to challenge the truth and accuracy of the witness's version. If a party is going to dispute certain aspects of the expert evidence, then they have a duty to cross-examine. If they simply put it in dispute and never cross-examine on those issues, then they're taken to have conceded to that evidence being admitted. So, you know, you can't turn around later and say, but we disputed it, because if you didn't actually cross-examine and put your case forward and put your version forward, then you're taken to have accepted that evidence. And the rationale behind this duty to cross-examine is that if you intend to argue that the evidence of a witness should be rejected, you should then give that witness an opportunity of answering points that are supposedly unfavorable, or which you see as gaps in their evidence or gaps in their opinion. So it gives them an opportunity to kind of, you know, further the case, further their opinion, not the case, as I said, further their opinion. You know, if and when you are called as an expert witness, also keep in mind that it's not you that is on trial. So cross-examination is nothing to fear. It might be an inconvenience in your life because it takes time often, but always remember that it's not you personally under attack. It's you know, just testing evidence, which needs to be done. So questions will be put to you on your findings, on the reasoning and the process you use to reach those findings, and These questions will either work to bolster your opinion or to find weaknesses and so doubt as to the reliability of your opinion. And especially where, it might be put to you that other reasonable conclusions could have been reached. That's obviously the attorney or advocate who's cross-examining you will naturally want you to make concessions that favor their client's case. And in those cases also, in those instances, it's not for you to decide what information to provide or withhold from the court. Even if, as I said earlier, even if it is facts that are not necessarily, that don't necessarily coincide with and reconcile with your opinion, they still need to be before the court so that the court can make the ultimate decision. Yeah, if a concession needs to be made, then just make it. It's then for the legal practitioner, the advocate or the attorney who's arguing the case, they'll need to try and argue it away if necessary. And a reluctance on the part of the expert witness to make concessions where they are indicated actually, has the opposite effect of what they'd think, and it moves to discredit that witness. So again, it's your own reputation that you're putting on the line. Being seen as a difficult witness and a difficult witness, it's never going to put you in a good light. So you want to, if you need to make a concession, make it. The legal practitioner will need to deal with the after effect thereof, and that is what closing arguments in legal proceedings is all about. It's about trying to persuade the court that despite this and that, this is still the only reasonable explanation and opinion and conclusion that could be drawn. Also, as an expert witness, when you are giving your evidence in court, you are entitled, I know here, I assume in India as well, you're entitled to refresh your memory using your reports and notes. So often these, your own notes and your own reports will be handed up as exhibits, but it's also important to remember that this doesn't form part of the evidence. The evidence is the oral evidence which you give in court. So if you need to consult your notes while testifying, don't hesitate to do so. Rather, take that opportunity to make sure that you are giving the court accurate and clear information. Then just some tips as well when testifying. Also I must say, I've never seen, you'll always find with expert witnesses that they are treated with respect in court. So on TV and in American films, we always see, these cross-examinations where it's like a personal attack on this expert witness. Definitely possibly happens there, but in most jurisdictions, that's not how it works. So it shouldn't be this personal attack on the opinion, on the evidence, the expert, sorry. I've only ever seen experts being treated with respect in court by either party and by the court itself. But as an expert witness, you need to make sure that the evidence you present to court should be and be seen to be an independent product of yourself, uninfluenced as to form and content by the exigencies of litigation. So you should also provide independent assistance to the court by way of, as I've said, an objective, unbiased opinion in relation to matters that fall within your expertise. You should never offer an opinion that you can't back up with facts and evidence, and you should certainly never offer an opinion on a subject that you are not skilled in. When you're asked questions, if there is a specific question that falls outside of your expertise, rather than answering the question, you should just make it clear that that falls outside your expertise. If you do attempt to answer that question, it could also be seen as potentially trying to mislead the court, which again goes to your credibility, not only in the case that you are busy with, but also in any other future case. You'd be surprised. There are judges and magistrates have exceptional memories, and if you come to court as a witness and you are found to be an incredible, if they find that you're not a credible witness, then that will affect you going forward if you're ever called again. And I've seen it in court where I've had witnesses because they have been found to be, unreliable and deceptive in court. And misleading the court is essentially deception. It's not just an error of judgment or a mistake, or it's deceiving the court. So also, as I've mentioned again, you should never assume the role of a legal practitioner, nor usurp the function of the court in attempting to decide on any matter which falls to the court to decide. The expert has a separate role in court proceedings, and their role is one of guidance. You are there as an expert to give the court the benefit of your knowledge and skill. It's not that you are specifically there to try and secure a specific outcome. You are there. Your role is an advisory one and a guiding one. Now, any facts or assumptions which you base your opinion on should be stated. For an expert witness to be really of any assistance, they should not only, as I've said, consider the facts which are favorable to their conclusion, but also the material facts which could detract from their concluded opinion. The court needs to be provided with all the information, and then after closing arguments, when the practitioners, the lawyers or advocates have an opportunity to try and persuade the court ultimately makes that factual finding. And if there's also a situation where you find that there's insufficient data, to really form much of an opinion, you should and must also state this, and just indicate to the court that your current finding is simply a provisional one, based on the evidence that you had received. But yeah, I would say overall, as an expert witness, you need to always bear in mind that you are not a party to those legal proceedings. This isn't your case, which is something to be thankful for. You get to walk away at the end of the day and put it behind you. But your duty lies with the court. Your duty doesn't lie with one of the parties, whomever hired you. Your duty is to the court to provide true and clear and relevant guidance. So, and at that, does anyone have any questions? I see we have, I think, 10 or just under 10 minutes remaining. Does anyone have any questions?
I will request audience, if they want to ask any type of questions, they can.
Thank you, Usha.
I think whatever you tell about expert witness today, they all are understood by our audience. That's why they don't have any kind of question. And thank you so much, ma'am, for such a valuable, informative, and detailed information about the expert witness, how they should maintain their ethics, their values, values and all the information you provided us related to the expert. Thank you so much.
Thank you so much for having me, and yeah, I wish you all the best going forward.
Thank you so much, ma'am.
Bye bye.
Now, I request our second keynote speaker, Advocate Miss Kanika Bhardwaj. I will introduce a little bit about her. She is a lawyer of both criminal and corporate sector, handling cases from all over Delhi, NCR, Mumbai, High Court, and Supreme Court of India. Apart from that, she had also acquired a position in a panel of Yamuna Expressway Industrial Development Authority. So I request Advocate Kanika Bhardwaj ma'am to start to continue the conference and share your views related to the concerned topic, ongoing topic.
First of all, thank you for such a nice introduction.
Thank you, ma'am.
And also, I would like to thank Forensic India to invite me and have me here for this session. Also, I would like to congratulate Forensic India for, bringing up this topic, because I personally feel that there is surprising lack of understanding of the role that witness plays in the court proceedings, which eventually may become a cause of injustice. That is my personal opinion. So thank you for organizing this particular session.
Thank you, ma'am.
And in India, I believe that people are, they are not aware of this right to call an expert witness into court, even though the laws are, well established. It is very surprising, but it is true. There is no debate or contradictions in law in India when it comes to the provisions of expert witness. But most of the people do not know the concept. So just in order to aware them, I believe this session will be really, really useful. Generally, when a person is summoned to court for giving testimony as a witness, he is expected to state only facts and not to give any opinion. So it is the job of the court, to form an opinion in the case. But there is an exception to this particular rule. The experts are considered as a witness, although they are not actually related to the case. The court requires these experts to give an opinion regarding a particular case to help the court having a wider perspective or a wider view to get the justice. Since judges do not and are not expected to have the knowledge of each and every science, for example, let's talk about medical issues, or when it comes to the opinion for electronic evidences, or opinion for a foreign law, opinion for fingerprints, handwriting experts, or opinion of a ballistic report, etc. So all these cases are very technical. These are such technical cases that we cannot expect a judge or a lawyer, to have knowledge of that particular issue. So all these provisions that one can find under Indian Evidence Act. So these are the provisions which are given under Indian Evidence Act. The court may take help of experts in cases that are lost because evidence is not produced before the court. What the judges can do, they can call an expert witness and take their opinion, take their help in order to decide a particular case. In India, very often we can see that the experts are called only in criminal cases and not much in civil cases. But apart from the criminal cases, there is a provision in civil cases as well, where the court can call the expert witness. For example, if we see the property case, we can call the registrar or the person from MCD before the honorable court. So there is a provision under civil laws also, but in India we experience um, calling the expert witnesses more in criminal cases. So yes, there is a well-established provision where the court can actually call the expert witness in the court. However, very often I have experienced the cases are lost just because expert evidence is not produced before the court. This is due to ignorance of the fact that producing expert witness is the right privilege of the both of the parties for a particular case. Most of the experts think that it is the duty of the court to call an expert witness. Hence, they do not exercise their right. Though the court by itself can call an expert if the judge needs any help, but it is not bound to call an expert opinion. Even I would like to add one point here that it is not only that only court can call the expert witness, even the lawyers, even the representative can file an application before the honorable court to call a particular expert witness which can help their case. But if we ask to produce an expert witness in our defense, court cannot refuse. This is also one of the very important point that counsels and the parties can keep in mind that even though if the court is not taking the cognizance or not taking on his part, he do not think that the expert witness is required in one particular case, but the counsel or representative think that the opinion of expert witness is very important and relevant in a particular case. So what he can do is he can file an application before the honorable court, and then it depends upon the court that he will allow or not that particular application. But yes, there is a right. So in one of the case, it is a case where petitioner requested the registrar of the National Consumer Dispute Redressal Commission to forward all relevant papers for the expert opinion, but somehow it was not done. So what Supreme Court has done was Supreme Court referred the case back to National Commission with a particular specific direction to seek the expert opinion and reconsider its judgment. Um, Also, in a very important case of Kathua rape case, which happened to be in 2018, and it is a very famous case in India, and there was a girl of 8 years old. She was raped and murdered, allegedly kept captive in a small village temple in Kathua district for a week. So, since there was no direct evidence to find out the guilt of the accused, and so the what court did was court immediately by its own motion, the court take the cognizance and he issued a forensic test for the victim's body. The examination by the doctors found that the girl had been drugged. The entire forensic research team played a very crucial role in this particular case. And with the help of the expert witness opinion, only this particular case was decided and the judgment came out. So this is how the expert witness and expert opinion is very, very important in a few of the cases. So when we come to the statutes and when we come to the provisions that what all are the provisions uh, regarding the expert witness and expert opinion. So if you will go through section 45 to section 51 of Indian Evidence Act 1872, you will find the entire provisions. So this is the only reason that when I said that the laws are already well established and there are no contradictions or there are no debates in India when it comes to such laws. So these are very well established laws. So before starting the technical part, first we should know that what exactly who is an expert. The court cannot form a correct judgment without the help of a person with special skills or experience in a particular subject. Or when the court needs an opinion in a subject which requires special assistance, the court calls an expert. We can also call it especially a skilled person, we can say. So therefore, an expert witness is a person who has skill, knowledge, and devoted time and has undergone training in a field he deems to be an expert. An expert is not a witness of fact, but the evidence provided by him has an advisory character. So this is also very important to understand that so basically the ordinary witness, he is a witness of fact. He tells the court the entire fact. He tells what exactly has been done uh, in a particular incident or in a particular case. But this is not in case of expert witness. Expert witness is a witness who has an opinion. who has an advisory character. So it is the duty of the expert witness to provide necessary information and scientific criteria to enable the judge to form his own independent opinion. It is upon the court or it is upon the judge to form his to take or to consider that particular opinion. But it is the duty of the expert witness to give the entire opinion based on the facts that has been presented before him. Now, as I was saying, that it is upon the court to determine whether the skill and knowledge amounts to an expert's opinion or not. Both the plaintiff and respondent have the privilege to bring an expert to assert and supplement evidence. The merits of the expert can be challenged during cross-examination. So another point is that the expert witness can be cross-examined, and both, even the plaintiff and even the respondent, they both have separate right to call the expert witness. Even in a particular case, if the plaintiff wants that an opinion of expert witness will help his case, so he can call the expert witness, or the other party can also call. So it totally depends upon the party and upon the court. But it is upon the court to decide that whether that particular expert, whether he is eligible expert or not, whether he is a qualified expert or not. And then again, the question is decided by the court only, that whether the opinion that has been produced by the expert, whether this opinion is, on that basis of that particular opinion, a judgment can be framed or not. So it is a general exception to the rule against giving an opinion in the trial. Generally, a witness is one who has seen, heard, or experienced criminal activity. Uh, he, However, an expert witness is a witness due to his skill, his knowledge, and discipline in a particular field. The opinion provided by the expert will be considered admissible evidence after the court has scrutinized and the method he has uh, employed. An opinion generates conviction. So what I mean to say here is that uh, the court and the judge will totally scrutinize the opinion which has been given by the expert witness. Without that, the court will not come to a particular judgment or a particular direction. The court will not give any direction unless and until the entire scrutiny has been done. So the opinion given by third person is considered as relevant facts if the person testifying is an expert. For example, the court was confused that letter has been written by a person or not. The court calls a handwriting expert to find out the same. So this person will be known as an expert, and the opinion which he gives in the case is very much relevant. There is another example that I would like to share is that, for example, if A shot B with a gun and subsequently B died, so a ballistics report will be provided by the expert to establish that the bullet came from the gun that A owned. So this is how it all works. So as I have already told you that section 45 to section 51 of Indian Evidence Act deals with the provision of expert evidence, and even these sections have provisions of their qualifications also. So particularly we talk about section 45. Section 45 of the Indian Evidence Act makes opinion of experts admissible. So this is a particular provision. It lays down that when the court has to, form an opinion upon a particular point of time or any technical issue, the opinion upon that point of a person specifically skilled in such science is a relevant fact. It is considered to be a relevant fact, and again, this provision has been pronounced in one of the very nice judgments of Supreme Court, which is a state of Himachal Pradesh versus JLL and others. The citation is 1999 SCC 280. So this is the citation, and it has been repronounced in this particular. So, however, the opinion of an expert is not binding on the court. This is very important to know, that there is a provision that you can call an expert and you can take an opinion, but that particular opinion is not binding on the court. It is stated in another one of the very famous case of Titley versus Jones, and the citation is AIR 1934 all 237. Sorry. So this is a very famous case of Titley versus Jones, and you will be able to find it easily on Google if you'll go and type that. So it is stated in Titley versus Jones that the real function of the expert is to put before the court all the materials together with reasons which induce him to come to the particular conclusion. So apart from the opinion and apart from the report that a particular witness is giving, and the court, he has to give a reasonable justification also, and he has to point out that all the sources also, that why he reached to a particular conclusion and how he reached to a particular conclusion. So on that particular opinion, the court may then form their own judgment. But then again, as I said, that has been explained in this particular case, that the opinion of the expert witness will not be binding on the court. Though the court can consider it, it totally depends upon the court that he will take that particular opinion into the consideration or not. So an expert witness, as I've already told, is not a witness of fact, and his evidence is really of an advisory character. The duty of an expert witness is to furnish the judge with the necessary scientific criteria for testing the accuracy of the conclusion, so as to enable the judge to form his independent judgment by the application of this particular criteria. However, an expert witness is subject to examination and cross-examination in the court. It has been laid down that without examining or without cross-examining of a particular expert as a witness in court, no reliance will be placed on the opinion that he has placed on record. So this has been said in another case of state of Maharashtra versus Damu. This citation is AIR 2000 SC 1691 at page 1700. So this is the citation, and it has been said that without the proper examination, without the proper cross-examination, the court will not consider the particular opinion of a expert witness. So the evidentiary value of the opinion of expert depends upon the facts upon which it is based, and also the validity of the process by which the conclusion is reached. Importance of an opinion is decided on the basis of credibility of an expert, we can say, and the relevant facts supporting the opinion. So its accuracy can be cross-checked. Therefore, the emphasis has been on the data on the basis of which opinion is framed. So, mere assertion, in a way we can say that mere assertion without mentioning the data or basis is not evidence, even if it comes from an expert, where the expert gives no real data in support of their opinion. The evidence, even though admissible, may be excluded from the consideration as affording no assistance in arriving at the correct value. So if it is not convenient for the expert witness to physically present in the court, or physically come into the court and give his opinion can also be taken by the way of affidavit or by a way of written questionnaire. But in India, it is mostly by the way of affidavit or video conferencing. Video conferencing is also, I believe, rare in India. So I would say, but yes, there are provisions. There are provisions of written questionnaires and telephonic conversations, and even video conferencing. There are provisions, but mostly it is done through affidavit only, and either affidavit or by the physical presence of the expert witness in the court. Mostly this has been, these are the ways through which we call the expert witness. But as I said that, yes, there are provisions of written questionnaires and telephonic conversations. So the affidavits of the experts, including, it can be any expert witness. So the affidavit can be taken as an evidence. Thereafter, if cross-examination is sought for by the other side and the commission find it proper or the court finds it proper, it can easily evolve a procedure pertaining the party who intends to cross-examine by putting certain questions in writing, and those questions also could be replied by such experts, including doctors or whatever the experts whatever the expert that has been called in the court on affidavit. So in case where stakes are very high and still a party intends to cross-examine such doctors or experts, they can be video conferencing or asking questions by arranging a telephonic conference or conversation. And at the initial stage, this cost should be borne by the person who claims such video conference. So it is not the court who will pay the cost. It is the person who seeks the video conference of conferencing, or it is the person who seeks the requirement of a expert witness. He will have to bear the entire cost. So further, the cross-examination can be taken by the commissioner appointed by it at the working place of such expert at the fixed time. And this has been said in Rule 4 in Order 18 of CPC. So you can go to Rule 4 in Order 18 of CPC and you can read this particular provision. So now coming to another very important head is that what is the evidentiary value of an expert opinion? So now we know who is an expert. Now we know that how an expert can be called to court, and even the affidavits and video conferencing can be done. And we know that there is a very well established provisions of calling a witness to the court. Now it is important that what is the evidentiary value of an expert opinion, because the entire expert opinion gives or is considered to be an evidence only. So it is important to know that how important or how relevant or how admissible these opinions are in before the court proceedings. So the very simple answer to this question is that the data given by the expert are very much relevant and they are very much admissible in the court. But the opinion of an expert should be supported by the facts, and it should be supported by the circumstances of the particular case. And if there are any contradictions in the statement or in the testimony of the ordinary witness and the expert witness, then obviously the judge will, he will first see what are the circumstances and what are the situations, and then he will come to a particular conclusion. So it is important that the opinion of the expert has to be based on the circumstances and on the situation. So there is a very important case of Forest Range Officer versus P. Muhammad Ali. It was concluded that an expert's opinion is not binding upon the court. Further, the opinion of an expert cannot supersede evidence of an attesting witness. A conviction cannot be based solely on the opinion of an expert witness. A conviction can be based solely on the opinion of an expert witness without substantial corroboration. So as per Section 293 of CRPC, the report of specific government scientific experts will be considered admissible evidence during inquiry, trial, or other proceedings of the court. So where the court is able to summon and examine the experts, if there is a conflict of opinion, the court has the final say in the matter. So the advocates, the advocates can also file, that I've told you that in such cases, the advocates can also file an application before the Honorable Court to call for the opinion of expert, but it again depends upon the court whether they allow your application or not. Or the court may also suo moto on its own motion and call for an expert opinion if the court finds it proper and it finds it fair. The expert witness will have to come before the court to give his statement. However, the personal appearance of the court is not important, as I've already told. In such a case where the expert is excused, he can send any responsible officer also on his part who is well versed with the facts of the case and report and can address the court with the same. If a judge relies upon the opinion of the expert only and not on the facts and the testimony of the ordinary witness to give judgment, then it is a weakness of the case. This is because even if a person is an expert in his field, he cannot be termed as a direct witness and cannot give a statement on the facts of the case. He is just giving an opinion as per the evidences given to him and cannot draw a conclusion regarding the guilt of the accused in all the cases. The evidence given by the expert is just an opinion and is not a fact based on testimony, and thus are given slight value. This is the reason that eyewitnesses or other factual witnesses are not given priority over the expert's opinion. This is because the opinion evidence cannot supersede substantial evidence. So no expert can claim that he would be absolutely sure about his opinion was correct. Expert depends to be a great extent upon materials which are placed before him, and the nature of the question which is uh, put in record, and which are already in record or has been put in front of him. So, however, the evidentiary value of an expert opinion depends upon the facts and circumstances. For example, I can say that if there is a dispute as to who is the biological parent of a child, the DNA report of the medical expert is of great importance. It is if the expert says that the DNA of the child or parent matches, then it is a relevant fact in deciding that particular case. But in case if a handwriting expert says that signature matches or not, whether the signature matches or it do not match with the person, this fact cannot be, we can not say that this fact hold much value, because there can be obviously a possibility that the person has practiced to copy a particular signature a lot of times. But on the other hand, DNA cannot be copied or changed. So this is how the expert's opinion depends upon the facts and circumstances of the case. So, Privy Council once observed that there cannot be any more unsatisfactory evidence than that of an expert. In the case of Emperor versus Kudrat, the court held that when the expert is giving a particular opinion upon the age by observing only the height, weight, and clothes, cannot be relied upon. The court must be satisfied that the accused is guilty. The court cannot hold him guilty merely because an expert is saying that his opinion of and he's making an opinion on the basis of the physical appearance, such as height, weight, and clothes. So a particular person cannot be held guilty on that particular opinion. The court needs to look into the evidence along with the opinion of the expert before giving any judgment or order. But then it is important that the court apply their own mind also, because as I said that the opinion of an expert will be admissible only in those cases where the facts and circumstances are supporting, and only in those cases the expert opinion will be taken into consideration by the judge, else it will not be taken into consideration at all. So I would like to also, talk about what is the difference between the ordinary witness and the expert witness, and what is the difference in their testimony basically. So the first difference is that the statement of the expert witness is not confined to what has taken place. He can additionally give his personal opinion, but his statement is not confined to what actually has taken place. For example, a doctor may not have attended the victim, but he um, uh, can still give his opinion as to the cause of the death of the victim and the after effects of certain poison or whatever the reason of the death is. So he can always come and frame his opinion even if he has not examined uh, the uh, the victim. So whereas the statement of an ordinary witness is always and always based upon the facts. He is not allowed to give any opinion. When a particular eyewitness or an ordinary witness comes into the court, he is not allowed to give his opinion, and neither the representatives will allow him, or neither the court will allow him to give his own particular opinion. He will only say what he has seen, or he'll only say, or he'll only talk about the fact of. But it is not in the case of expert witness. Expert witness will only give his opinion. Another very important difference is that an expert can refer to and rely upon the experiments conducted by him in absence of the other party, whereas an ordinary witness has no such right, where he can refer to any past experience to support his statement. Uh, so this is the difference. Another difference is that an expert can refer to well-known books, or he can quote passages from same as a reference for refreshing his memory. An ordinary witness cannot rely upon books or cannot rely upon statements uh, that this particular statement is based on this fact which has been mentioned in the book, or so the expert can refer books and quotes, but ordinary witness cannot do that. Also, the expert witness has to be qualified in first place in order to frame opinions. But in case of ordinary witness, there is no qualification required. He just have to come to the court and say what the fact he has seen or what fact he knows. Yeah, there is no particular qualification that he requires, but the expert witness requires a particular qualification, and the qualification has been given in Indian Evidence Act that you can go through. So, what are the though we have discussed about this, what are the prerequisites of expert evidence? So, for the sake of consideration of expert testimony, there are two important conditions that are necessary to be shown before the court. The first one is that the subject is such that expert testimony is essential. So, the provision of calling an expert witness in court is optional and not mandatory. There, in order to call an expert witness, it is essential to show that the opinion of expert is necessary in a particular case. For example, we can say that if there is a particular audio recording in a case of blackmailing, it becomes important to prove that whether that particular audio recording is of excuse or not. So in such case, it becomes mandatory to call the expert witness. The second point is that the witness is in question is really an expert. So it must be proved that the witness is competent enough to give the evidence and that the fact to be proved a point of science or art of which the witness is an expert. It should be proved before the honorable court that he is qualified enough to frame an opinion. If a witness is not proved to be an expert, his opinion will obviously his opinion will be irrelevant then, and it will not be admissible also at one point of time. So it must be proved that the witness is an expert. He must be examined as a witness in the court and be subject to cross-examination also. The very famous Supreme Court judgment, there was a case of Ramesh Chandra Agarwal versus Regency Hospital Limited and another. In this case, the basic requirements of expert evidence was laid down, and the court stated that the first and foremost requirement for an expert evidence to be admissible, in fact, that it is necessary to hear the expert evidence. The first important thing is actually basically a test has been mentioned, and in this particular judgment that there should be a test whether the expert witness is qualified enough or not, whether he is an expert or not. So the test is that the matter is outside the knowledge and the experience of the layperson. This is also one of the important points that the court must be of an observation. There must be an observation by the court that in a particular matter, it is important to take opinion of a third person. So in that case also, the court can call for the expert. So there are two, basically in this judgment, there are two tests that has been mentioned. The first one is that the expert has to prove that he is an expert. He is qualified enough to frame an opinion. And the second test is that whether a particular matter in a particular case, is there any requirement of an expert or not? So when a person or a case qualifies these two tests, then the role of expert witness will come in a particular. So there are few important provisions that I would like to discuss with you all. Though as we know that there are section 41 to section 51 talks about the expert witness and the provision, but I will talk about only few provisions as in here which are important. So section 45A is important. Section 45A talks about opinion of examiner of electronic evidence. So in a matter proceeding, when the court has to form an opinion on any matter relating to any information transmitted or stored in any computer or any electronic or digital form, so opinion of examiner or electronic evidence referred to section 79A of IT Act 2000 is a relevant fact. So in that case, this particular section comes into the role. Then another section we talk about is section 47 of Indian Evidence Act, which refers to the relevancy of opinion as to handwriting. So when the court has to form an opinion as to handwriting of a person, the opinion of a person who is equivalent with the handwriting of the former person is admissible evidence. The third provision is section 47A of Indian Evidence Act, it talks about relevancy of opinion as to electronic signature. So when the court has to form an opinion as to the electronic signature of any person, the opinion of the certifying authority which has issued the electronic signature certificate is relevant. Another section is section 48, which talks about the relevancy of opinion as to existence or right or custom. So when the court has to form an opinion as to the existence of any tradition or any custom, then this particular provision can be taken into consideration. For example, if I say that, in the case where the parties are maybe a tribal family, so we know that the tribal families have their own customs and they have their own traditions. So there comes relevancy of opinion as to existence of right or custom or any tradition. The next one is section 48, which, okay, the 48 we have already done, sorry. The next section is section 50. Section 50 talks about relevancy of opinion as to a relationship. So when the court has to form an opinion, a particular opinion as to relationship of two persons, then this section can be taken into consideration. For example, the court has to establish whether the son, whether maybe in the cases of inheritance of property, whether the court has to examine whether that son is basically his legitimate son, or they can match the DNA. The court, the one of the party can take a defense that he is not my son or she is not my daughter. But in order to establish the fact, the court can call for DNA, DNA experts, and the court can consider this particular provision also apart from the medical experts. So after discussing all the provisions of all the Indian Evidence Act, I would like to talk about what expert can do and what expert cannot do. So what now I'm telling you the pointers that what experts can do. So the first one is that he has to provide an independent expert opinion in their area of expertise on the subject matter in accordance with the instructions they are given. These instructions will be shown in the expert witness report, which will be seen by the court other side and which will be seen by the other side also and the court also. So apart from this, he has to provide the opinion in the form of report, and also he can provide an opinion in the form of the data or before the honorable court or the tribunal as and when required. The report is required as it is not usually possible for the expert to give evidence without it. So generally experts give their report also apart from that, apart from their opinion, they give their report also. So it is the duty of the expert to ensure that the report that has been provided contains the information required by the court rules. If you proceed, you will have to give a copy of the report to the other side in the dispute. At that time, a copy of the other side expert report will be given to you. So the report will be exchanged between the parties, and one of the report will be given to the court. So it is mandatory that, and also it is the duty of the expert to give the entire relevant knowledge that the court has asked from that expert. Apart from that, it is the duty of the expert to comply with the specific procedures and all the rules that are applicable. Also, he has to provide truthful and impartial and independent opinion whether or not these opinions favor your case. So he has to be very independent and impartial in order to be fair. So an expert witness also has an overriding duty to the court. This duty supersedes any duty owed to you, even though you are still responsible for paying the expert fee. So he has the overriding duty also. Apart from that, there are a few pointers that I would like to discuss that what expert will not do, that he will not do. So the first is that expert will not be your advocate and he will not argue your case. So he will only help you finding a particular opinion that the court has asked. He will not represent your case in the court. So he will not provide an opinion beyond his specific area of expertise. This is also one of the very important things that expert cannot do. He will only make a report, or he will only say what has been asked by him and what is relevant for the case. Also, the expert will not provide any advice. He cannot provide any advice. Also, except any appointment which involves a conflict of interest, um, he cannot widen his area. He will be very specific. If the court has asked a particular question, for example, the court has asked upon the DNA, the expert will reply and make his report on DNA. He cannot widen his scope, and he cannot give his additional advice in the court. And also, he will not act as a negotiator. So another point is that uh, this is important point, that you should know that keep the expert informed of developments in the case and of all the key dates and good times. So this is your duty basically, or this is the duty of the representative. We can say to keep the expert informed about what developments in the case has been done. So the expert cannot he will not come and take the developments and make the pointers. It is your duty. So it is better that the legal representative deals with the expert rather than a person or a client in particular doing all these things. It is better that a legal representative should do all these. So, concluding the entire session, I would say that it is evident that the scope and the areas wherein expert witness can be called for has widened due to advancements and various judgments. However, due to various factors such as partiality or favoritism, we can say, or indirect involvement, the evidence submitted by an expert witness cannot be solely used to be cannot to be uh, uh, made basis of a conviction. This form of evidence is generally considered weak evidence that requires further corroboration. However, evidence that are based on scientific principles and are not dependent on the opinion of the experts, such as fingerprints and blood tests and DNA, have a stronger evidentiary value. And the onus of to prove the reliability of the expert witness evidence is upon the party calling for an expert witness. As a rule of thumb, courts are cautious reviewing expert advice. So, there may be cases where the court advice is taken, where the expert advice is taken into consideration or not. But this is a very important fact, that there should be no favoritism, and the court should take more measures and should work more in this particular area, that in order to ensure that there is no partiality and there is no favoritism, because there are many problems in India. For example, there is corruption also. This is a very practical aspect that I'm telling, that what people do is that they bring corruption into the thing, into the case, and then the particular expert, he only gives his opinion based on from whom he has taken his diet money, we can say, in one aspect. So all the court must ensure that there should be more rules and there should be more strictness of laws uh, in order to ensure that the expert witness opinion that he is giving, that that particular opinion is fair and it is not partial and there is no favoritism. So with this, I conclude this session and I hand over to the Forensic India team to conclude this.
So I request my audience, if anyone want to ask any questions from the ma'am. There is one question from Ritam Chatterjee. So yes, sir, you can ask question. Hello, ma'am. I read the sir's question and you will answer. Okay. So एक minute. Wait. Okay. So the question is from the Ritam Chatterjee is it as a defense counsel, is it possible to bring an expert other than the person who conducted the medical examination?
See, in that case, there is a very when the person has already conducted a medical examination. In that case, you can call a defense, you can take your defense, but in that case, you have to file a particular application in the court. You have to file that application, and then it is totally upon the court that the court will take cognizance of that application, whether the court will allow that application or not. So, you have to mention your grounds also, that why you want a secondary opinion, why you want to call a particular expert witness when already the medical examination has been done. So why do you want to call a particular expert witness in the court? If the court is satisfied by your grounds, if the court feels that it is relevant and it is important that such expert opinion should be produced on record, or it will help the particular case, then the court will definitely allow. And there are few judgments also. You can find, if you have few judgments, and if you quote few of the judgments in your support, I would think that I would suggest that that would be a better idea, and that would make your application much stronger, and there are more chances that your application will be allowed in the court. So yes, it is a possibility then, but it all depends on the application that you are filing. Though there is a provision, yes, we can say provision is there.
Any other questions?
You're most welcome, Ritam.
I think no one want to ask any other question.
Right.
So, thank you so much, ma'am, for your valuable and informative session.
Thank you so much.
Thank you, ladies and gentlemen. As we end today's event, today's conference, I would like to thank you all for joining the conference. Your presence today show a strong commitment to work. In particularly, Forensic.India would like to express their sincere gratitude to the speakers for sharing their expertise with all of us. The presence helped to make this conference a great success. At last, Forensic.India wishes you all the best and hope that you will continue to be engaged with us for more upcoming events. Thank you all. Thank you so much. Take care. Stay safe. Bye bye.